Hi, my name is Erich Straub, and I'm an immigration attorney with Straub Immigration. In this video, I'm going to talk to you about deferred action and a very exciting announcement that President Obama made on June 15, 2012, that extended deferred action to a class of people commonly known as dreamers. So let's talk about deferred action first. Deferred action is not a visa. It's not lawful permanent residence in the United States, which some people commonly refer to as having a green card. It does not provide a pathway to citizenship. It is a temporary form of relief. And essentially what it is the government is saying you do not have status. We know that we could deport you, but we're not going to do that. We're not going to put you into deportation proceedings. And deferred action normally allows someone to apply for work authorization. So we're going to let you stay here in the United States. We're going to let you work. But there are some very important limitations to deferred action that everyone who is considering applying for it should be aware of. And so one of those is deferred action is temporary. Again, it's not permanent residence. It's not a visa. And really, you're at the whim of the government in terms of allowing you to stay in the United States. Now, for dreamers, the government has proposed that deferred action would be for a 2-year period. They've also proposed that it would be renewable. We don't know for what period of time it would be renewable and how many times it would be renewable. Those are still things that are to be determined in the future. It also does not allow a pathway to citizenship. So in and of itself, deferred action will not allow you to ultimately become a United States citizen. And then lastly, deferred action will not allow you to travel outside of the United States. If you have deferred action and you travel outside of the United States and then try to re-enter, you may not be admitted. So those are all very important limitations to deferred action. So those are the limitations of deferred action, but let's talk about the benefits. And actually, we've already talked about 2 of them. Deferred action gives you a limited or temporary relief from deportation proceedings. So again, the government could deport you, but they're choosing not to do so. It does not mean that in the future they will not, but temporarily they've decided that they're not going to. Secondly, it gives you work authorization. So what you can do is apply for a work permit and get a job in the United States. It also allows you to get a Social Security number. It allows you to get a driver's license. So those are very, very important benefits, particularly for someone who in the past has had no status and was unable to take advantage of any of those opportunities. So we're going to get to the requirements for deferred action in just a minute, but before we do that, there's something very important that I want to tell you about this video, and that is that it is for informational purposes only. You do not, by watching this video, have an attorney-client relationship with Straub Immigration, because in order for you to have an attorney-client relationship with us, you would need to talk to us about the circumstances that are particular to you. And so we can't do that, obviously, in this video. So we've talked about the benefits. We've talked about the limitations of deferred action. Let's actually get to who qualifies for deferred action. And so one of the most important requirements is that you have to have come to the United States while you were under the age of 16 years. You also cannot be older than 30 years of age. So those are the age requirements. There's also a requirement that you be present and that you have lived in the United States. And this is a little complicated and uses a lot of immigration terminology. So let's take a minute and kind of break this down. Well, first, you have to be present on June 15th, 2012 in the United States, and you're going to have to prove that. Secondly, you're going to have to prove that you continuously resided in the United States in the 5 years prior to June 15th, 2012. So in essence, you're going to have to show that you continuously resided in the United States from June 15th, 2007 to June 15th of 2012. In addition to the presence or residence requirement, there's also a requirement that you have a certain amount of schooling or military service. So let's talk about the schooling requirement first. You have to have at least graduated from high school or currently be in school or have obtained a GED. In terms of the military requirement, you have to show that you've been honorably discharged from the armed services. So you're going to have to show one of those in order to meet this requirement. The last requirement is that you have to show that you do not have a significant criminal record. So U.S. Citizenship and Immigration Service has provided us some guidance as to the types of criminal convictions that would disqualify someone from applying for deferred action. A single felony conviction is going to be considered a significant criminal record. So that's probably the clearest cut guidance that United States Citizenship and Immigration Services have given us. The government has also told us that a second disqualifier would be for a significant misdemeanor conviction. And what have they defined that as? Well, it could be a violent offense, a sex offense. It could be a crime of fraud or theft. A drug offense would be a disqualifier, as well as a firearms offense. Obstruction of justice crimes or fleeing from an officer. And the one that probably has the most people concerned, drunk driving. And so the third category that would disqualify someone as having a significant criminal record, the government has told us would be multiple misdemeanors. And that would be 3 or more misdemeanors that did not occur on the same day and did not arise out of the same scheme of misconduct. So we've talked about the requirements for deferred action, and we've talked about the things that will disqualify you from deferred action. So your next question is probably, well, when can I apply? And the answer is that we don't really know. The government has told us that they're going to be issuing additional guidelines to the program by August 15th of 2012. So we will probably know on August 15th of 2012 when you can apply. This is a really important point because any time we have a change in immigration law, unfortunately, we have a lot of scam artists that pop up and try to tell people that they're eligible for something or that the law has changed before it actually goes into effect. So you need to be careful. And again, I would strongly encourage you, if you're thinking about going forward with this, to consult with an attorney. So what are some of the dangers or the risks to applying for deferred action? Well, one of them is probably pretty obvious. If you're in the United States and you don't have status, the government may not know that you're here, and by filing for deferred action, you're notifying them that you're here and you could be deported. Of course, we hope, and I think it was President Obama's intent, to make this the first step in a process that will eventually lead to permanent residence and citizenship. But again, as we stated at the beginning of this video, this is a program that is temporary in nature. So whether the risks make sense for you given your circumstances are something that you should carefully consider after consulting with an immigration attorney. The second area that I want to highlight in terms of risks or dangers is for persons who have criminal convictions. And so this is an area of great concern. Anyone who has a criminal conviction should always consult with an immigration attorney before making any type of application with Citizenship and Immigration Services. And the reason you want to do that is because there are provisions in immigration law that make you automatically deportable from the United States based on certain criminal convictions. Also, even if you don't trigger one of those automatic deportation provisions, your case is going to be less sympathetic to the government. So if you are somebody who has a criminal conviction or record, it is vital that you seek the advice of an immigration attorney before you file any application. So a little bit earlier we talked about that important date of August 15, 2012 in terms of that's the day that the government is going to issue additional guidelines. Does that mean that you have to wait until that day before you can do something to prepare to file deferred action? Actually, it doesn't. There are things that you can do now if you believe that you may be eligible for this, so that you're ready and prepared when those guidelines are issued and that you're able to file quickly. So let's talk about what some of those things are so that you can get ready now. Well, the first thing that you can do is you can consult with an immigration attorney. And as I've stated repeatedly in this video, there are risks that are involved in this process, and that's something that you need to very, very carefully consider. Whether you're someone who has a completely clean record or you may have some criminal convictions, you need to seek counsel of a competent immigration attorney before deciding to move forward. A second thing that you can do may seem pretty obvious. You can stay out of trouble. You need to avoid any arrests, contact with law enforcement, or any convictions. You need to be aware that the government is going to take a very careful look at you, and essentially they're going to try to assess whether you're somebody that they want to keep in our community or not. And obviously, convictions can have a huge impact on that. So the third thing that you can do to prepare is you can begin to gather the evidence that you're going to need to establish your eligibility for deferred action. And so if you remember earlier in the video, we talked about a very important date, which was June 15th of 2012. And remember, you're going to have to show that you were present in the United States on that day. And you're also going to have to show that you lived in the United States 5 years prior to that day. So how are you going to show that? Well, unfortunately, the government's probably not just going to take your word for it. So you need to get some documentation. And some of the documentation that you can gather would be a lease or a mortgage that shows that you were actually living and you had a residence in the United States. Maybe you don't have that. So what are some other things that you can gather to show that you were here? You might have school or medical records. You might have financial records. Some people have been employed even though it was without authorization, and you may have records that show that you were employed in the United States. Also, if you're going to establish your eligibility through your military service, military records can often take several months to get a hold of, so it's important to get an early start to establish that you were honorably discharged and that you served in the military. So we're almost at the end of this video, and what I've tried to offer you is an overview of what the eligibility requirements for deferred action are. Some of the things that you can do to prepare to file your application for deferred action, but one of the most important things that we've talked about is some of the risks and dangers that you're going to have to assess in terms of whether to file for deferred action. And I just want to remind you again that this has been an informational video, and in order for you to fully assess and make an informed decision about whether to go forward or not, you really need to seek the advice of a competent immigration attorney. At Straub Immigration, we have a reputation for achieving results in even the most difficult of cases. And whether your case turns out to be fairly straightforward or one of those difficult ones, I would welcome the opportunity to represent you.